Our army of realtors that we work with, 9,000 strong across the country, we talk to interested in being told what to do and how to do it. So I think that even though HAFA, and we've done quite a few of them, is a great program and it's going to create some streamlining, which it already is doing, folks, right in the middle, 4.1 million and growing loans that are issued in Never Never Land. That's the problem right there. You can see that delinquencies are growing. The foreclosure rates are artificially low right now because of the robo-signing and sales in the month of, I believe it was May. It's nothing. It doesn't solve the property because of all the concern and problems. And ask your title partners what they're telling you about the number there to look at. So there is some increase in price in the market depending on your location. Breakdown, you can see pre-foreclosure, there's short sales, auction properties, bank-owned, 29% of the market and growing. This is the segment of the market that the agent community needs to focus on. A difficult time getting these transactions through the process, regardless of what the banks say they're going to do, regardless of what they can cause problems. And part of it is true and accurate. The majority of files submitted to banks by realtors and attorneys and title companies are incomplete, inaccurate.
Has questions either if you're sitting up front or you want to go to the microphone, Darren. It's about a quarter of the way up. While everyone's getting to the microphone, I'm gonna Bill, Bill, you're ready. Great.
I'm ready, Ed. For Shari or Stephen, I'm getting questions from members on MERS. I know there's been cases in New York, California, and Oregon. Is that anything other than Robo-Signer Gate 2, or is it something more significant than that? Is it really going to delay the clearance of the market?
I'll let Shari go. I'll let Shari do it from the legal aspect. I'm going to do it from the practical aspect. What MERS is intended to do, and is this? There we go. What MERS is intended to do is to inform the community under the FTC's brilliance and thought process to avoid fraud. That you're disclosing that you're just an agent, you're an expert, you're doing this, and then there's various disclosures, time of listing, an advertisement, when a lender makes an offer or an approval, that you're to include with that. Now, last week they have suspended it because they're going to transfer it over to this CFRB, and they're going to move the rights out there. So I think that federally wise, I don't think they're going to do anything, but you have to look at it from a statewide perspective. The teeth on it are pretty significant if they come after somebody for doing the fines are astronomical for what, in my own personal opinion, is just another piece of paper that's blocking the ability to help people. It's designed to weed out the fraud, but we all know that if someone's going to try to take money, they're going to do it regardless of what the government says you can or can't do.
Are you referring to that, or are you referring to the mortgage electronic registration system?
Oh, okay. MARS.
Okay.
I'm going to MARS.
I get those
Sorry, excuse me. Better handle MERS.
Yeah, and there was also a recent case in Massachusetts. That's a really interesting issue, and that, is everyone familiar with the mortgage electronic registration system? Can you raise your hand if you are? Okay. Just for those who are not, it started, about 10 or 12 years ago, just as a central clearinghouse. One of the problems that we've had, and that created Robo-Signer Gate to begin with, was that, of course, the industry changed so much in terms of what was happening to those pieces of paper. You know, mortgages became decentralized and securitized, but the sort of hands-on pieces of the industry never changed. So MERS was thought to be a very good solution at the time, and I think probably is. The mindset didn't keep up, and that's why we have Robo-Signer Gate. I mean, the truth is that those assignments that are at the key to, all of these issues, it's basically the whole Robo-Signer Gate issue. It arises out of the fact that a lot of the mortgages are alleged to have not been properly assigned to the next person in line, and then, of course, you had these big foreclosure factories who were signing affidavits basically saying that it was. And they were doing that at a very rapid rate. But the reason that Robo-Signer issue came up in the first place is because those systems just didn't keep up. So, in other words, Fannie Mae was paying foreclosure attorneys, residential foreclosure attorneys, $800 a file. Now I think it's up to like $1,200 or $1,400 a file. I can tell you, I do commercial foreclosures in my work, and those cases can take hundreds of thousands of dollars in legal fees. On occasion, we'll handle a residential foreclosure for a good client, and the fee is $15,000 or $20,000. So that's the minimum that it really costs to handle a case like that. To try to do it for $1,500, which is what these law firms are doing, is just impossible. So everyone knew at every level that robo-signing was going on, because you have to cut corners and able to do the work for that price. And there's a reason you want to do the work for that price, because in the recourse states, and by recourse we mean a state where if the property eventually sells at a foreclosure sale, it doesn't make enough money to pay back the mortgage, so the homeowner still would owe some money, and some states do enforce those judgments and other states don't. But in a recourse state, the borrower is responsible for the legal fees. So we want to keep the legal fees down. I don't think that RoboSigner-gate is going to go away for a while because we've never fixed the core problem. The core problem at the bottom of RoboSigner-gate is that you cannot do a residential closing the way foreclosures, the way they have to be done today for $1,500. You just can't do it. And that's why when they moved all these files from, for example, David Stern's office, there were like 3 law firms that stepped up and were willing to take them on. No one wanted to do it because you can't make money doing it. So we've got to streamline, and this is a big foundational issue. You know, we've got 50 states with 50 different foreclosure processes. And not only that, but within each state, you've got judicial circuits that each have their own process. And then within the circuit, each judge can require this piece of paper on top. We've got to streamline the foreclosure process so that it's uniform, so a law firm who's handling foreclosures across the country can do it, and can do it for $1,500. Otherwise, we will always have robo-signing. And the affidavits themselves were actually not meant to protect homeowners. They were meant to, the affidavits that were allegedly robo-signed were meant to protect the banks, to make sure that the right bank got paid and the right bank was exercising the foreclosure remedies. These Borrowers Defense Counsel have taken it and run with it and converted it to be something that wronged the borrower. But, the issue is not whether the borrower owes the money. I mean, it's just the issue of which bank the borrower owes the money to. So the whole idea that, mortgages should be forgiven because of robo-signing is ridiculous. No one's saying they don't owe the money. It's just the wrong bank. I don't know if that answered your question adequately.
But what's going to happen with the legal cases? I mean, so there's 4 states that you've mentioned, that I'm familiar with. Is that going to spread? I mean, is there going to be some final legal decision that says, yeah, you can use MERS for this or you can't?
Did everyone in the back hear that?
Sorry.
Oh, the ramifications of the legal case.
We have to be able to use MERS. I mean, we have to be able to. You can't, unless there's going to be a law against securitizing mortgages, you have to be able to use MERS. It will spread, and we're going to see this going on, sort of indefinitely because it's such a political hot potato at this point. It's interesting, I don't know if you were aware of this, but there were 2 assistant attorney generals who first blew this case in South Florida. They were actually right in Broward County. And you can read the depositions online from the paralegals who kind of spilled the beans about this robo-signing. Was anyone aware of those depositions that sort of started all of this? Well, those 2 attorney generals were let go. They just got fired under very suspicious reasons. No one really knows why, and I happen to know one of them for a long time. So it may be that the whole robo-signer carpet, may get pulled out from under the whole entire situation. There may be some mud on some people's faces because the whole thing really got out of control. But, you've got politics involved and you've got a lot of people needing to save face. The other issue with RoboSigner that's interesting from a realtor perspective is that people buy, if there's really an issue with RoboSigner, then the real issue is with the title that the new buyer is getting to that property. That's, if there's a problem, then that's the problem. The biggest underwriters, like Fidelity and First American, have cut a deal with the biggest banks, like Bank of America, and Bank of America is basically because the underwriters wouldn't insure title to these things. Everyone who's an agent for a title insurance company got a memo that says, do not insure title to any foreclosures that were foreclosed during this time without calling us first. And so I, of course, am a busybody, and I called, and I was like, okay, well, when you call, what are you going to tell us, Oh, well, we're doing it on a case-by-case basis. So what they did is they struck a deal with the Bank of America, and Bank of America is basically indemnifying them. So the whole thing goes full circle. So you've got this innocent home buyer in the middle now who's buying a property that was allegedly robo-signed. If there really is an issue, that homeowner can come back and make a title claim, which is Kafkaesque in itself. I mean, who wants to buy a title insurance claim, right? If you're an innocent homeowner, you're going to sue First American. If they make the title claim, First American is not going to pay up, or Fidelity. They're going to go back and say, Bank of America, you've indemnified us. So now, guess what? This new innocent buyer has an issue with Bank of America. So, no one really knows how it's going to end up, but it could have some hairs that we're not really expecting.
Right.
Did I answer your question the second time I got a shot at it?
Yeah.
Okay.
Hopefully I covered the MARS thing, which was Mars, MERS. I mean, the acronyms are pretty flying around.
We got all the alphabets covered.
Here we go.
I think it's great that there's this alphabet soup of acronyms that's out there, and then you couple it with a very uncertain regulatory environment. But as a government affairs professional, a lobbyist, the one thing I think that's of concern, and I love how you mentioned takeaways. I think takeaways are important, but I think it's absolutely critical for the NAR staff that are here. If there's no standardization on what you guys are facing, there's absolutely no standardization in what we can teach. And if there is no standardization in what we teach, we cannot teach. So I think there's going to have to be a role at some point very quickly from NAR to set a standard for not only for our members and what they are teaching those folks that are going out there, because if I know my members well, if they see a new business model that emerges, they're going to jump to it. They're going to jump in with both feet, and they're going to put themselves at wide risk. But the last thing I want to position myself in is to share information with members without a solid standardization of it. And I think that's something that we're going to have to look to from NAR very quickly in the short term, because if our speakers are correct in what they're saying, those regulatory factors I think are well beyond most local GADs, I would argue most state GADs and their staffs, to look at on a regular basis of what's going on, and not only be able to message that out to our membership of what's going on, but moreover articulate it with authority that this is the path they can take. You can put out a list of regulations, but if you can't give them the tools that help them profit from it, which is what we're supposed to do, I think, and Dale Stinton said it best, keep our members out of jail and make them profitable. This is one example. This precise issue is one example where both things could happen depending on how we act. So I hope if there are any of our staff here that they take that message back, because I'm not prepared in many cases to go through this alphabet soup and then tell Susie Realtor or Bobby Realtor, this is a great opportunity, go do it.
I have a suggestion on that, because I have said from the very beginning, from the day the crisis hit, that we really need some really good realtors, and I promised someone I would not say realtor, even though I never said that anyway. But I myself am a broker, so there's no such thing as a realtor, if you ask me. But anyway, I think what you can do in a situation like that is sort of highlight some of the suggestions that maybe were raised in terms of revenue. I think, mediation is awesome for realtors. If you can become a certified mediator, it's not difficult. It's a good revenue source. It's something else on your resume. Focusing on the rentals, looking at the lease for deed programs, looking at, the community preservation programs, looking at investors, because there will be more programs for investors who are willing to rent at a set rate of return, like 15% over 5 years or something like that. But I think what you need to do is take those concepts and then decide on, which one or two for your particular jurisdiction, and then bring in the expert to focus on that one thing. Because, the educational component it's very specific. I mean, look at a room like this. We're all exhausted from giving our presentations because we were like on crack, because we knew we only had like 10 minutes to tell you. Yeah, Rugus and crack. It's a Judy Garland thing, So you need.
Statement begs the question, though. Again, the tool for the GAD that's going back home.
Can everyone hear back there?
The issue for the GAD going back home is, and again, the ask is, NAR is going to have to provide us that list of resources of who these experts are, certified by somebody that says these are the people who know, because invariably, like this gentleman over here, you're going to get questions on some aspect of the thing. I just need to know where that gets passed off to, because if it's going to an NAR staffer, we're going to start burdening these people, provided that the growth patterns of 6 million foreclosures that are on the horizon, if you do the math, are there. We're still going to need those resources.
Right.